Are you a Canadian who's been waiting for answers when it comes to how on earth public health officers across the country in Canada were able to get away with mandating divisive policies that separated families, kept loved ones away from dying loved ones in care homes, has still kept healthy, capable, and able healthcare workers from relieving critically understaffed healthcare systems in provinces like British Columbia and Nova Scotia? Well, today in BC, at least, it's possible that citizens may be on the path to getting some answers.
First, we need to give everybody the opportunity to be immunized. That is really important in healthcare, and I have very little patience for people who aren't immunized in healthcare, and that will be, we've had a vaccinator mask policy for influenza. We will have a very similar policy that if people choose not to be immunized and you work in healthcare, then you will not be able to work in certain settings without taking additional measures. There will be consequences for that decision.
I'm Drea Humphrey with Rebel News, standing in front of the Supreme Court of BC because today a hearing brought forth by the Canadian Society for the Advancement of Science and Public Policy is happening. It's a hearing seeking to be certified for a class action lawsuit against Dr. Bonnie Henry's mandates. Actually, it's more about the declaration of a COVID-19 emergency in the first place.
This virus has shown us that there are inequities in our society that have been exacerbated by this pandemic. And there is no way that we will recommend inequities be increased by use of things like vaccine passports for services, for public access here in British Columbia. And that's my advice, and I've got support from the Premier, and I have talked about this, Minister Dix and others.
All right, this is Eva Chipiuk with the Institute of Freedom and Justice. Now, how did you get connected with this CSAS case?
Hi, Drea. So what happened is the Institute for Freedom and Justice has partnered with the CSAS group to raise awareness and provide educational content about the class action that they brought forward over 2 years ago.
That's right. A lot of people don't even know this case exists. And I mean British Columbians at that. Rebel News has covered it a lot. There has been the odd report of it in the state-backed media. But basically, this is a certification hearing or seeking the certification to be able to do a lawsuit, a class action suit that really attacks, I say, the Achilles heel of every COVID-19 measure that Provincial Health Officer Dr. Bonnie Henry mandated. And that is by challenging whether or not there should have been a declaration of an emergency, right?
Yeah, that's right. So it's quite a unique application, and that's why it's really great that people are talking about it now. So it's not directly attacking any of the COVID measures themselves, although indirectly, of course, it is. But the big attack is on, and the big challenge is on Bonnie Henry and the province's declaration of emergency, state of an emergency. So what was that based on? What was the evidence, and whether that was reasonable and legal at the time?
Today, we predominantly heard submissions from Crown lawyer Emily Lapper. So it's always hard to stomach if you've valued freedom and opposed the medical tyranny. And one of the main arguments that we heard from Crown today was that they want this case dismissed on the grounds of abuse of process. They're basically saying, hey, this society has argued this issue previously with another court case we've covered, which was a vaccine passport challenge. They're saying Chief Justice Christopher Hinkson has already ruled on some of these issues and more. So this should be tossed out. This is an abusive process. What do you say about that?
Yeah, so that's one of the arguments they were making, and certainly they're entitled to make those arguments. From my understanding, it was a very different case, and I understand that CSAP's lawyer is going to get to this on Friday. But as you said, that was about the vaccine mandate. As we've discussed already, this challenge is specifically about the emergency declaration. So it's a lot broader. Number one, it doesn't just talk about people that weren't vaccinated. It talks about anybody not being able to leave their house. And that was a big point that started it today, is that literally if you use the word imprisonment, that would be the correct word, or house arrest of people not being able to leave their homes because they had COVID. And there were times when the house arrest or imprisonment was 7 days or 5 days. So that had nothing to do with the vaccine mandate. So it is a very different challenge in my view, and I don't think this is an abusive process. And I'm actually going to add on to that is I think it's very difficult for me to swallow the government lawyers, the Crown lawyers, accusing or arguing the plaintiffs, saying that it's an abusive process. This is a very complicated challenge to bring forward. Any class action is. At the same time, this case has been a moving target. So what do you expect from regular Canadians? These are good Canadian citizens. You could see in the courtroom itself that these are a wide variety of Canadians coming together, trying to actually do the opposite. They don't each want to come into court filing hundreds of thousands, or let's say millions of these lawsuits. Right. That might be an abusive process. What this group is doing here would be the opposite of an abusive process, in my view.
Yeah, it was most definitely a full day in court. The lawyer on behalf of the society, CSAS, which is Paulina Fortula, she also pointed out the difference that in this case, the society is seeking damages. One of the other arguments, because again, this was Crown's day to shine today, one of the arguments was that they're claiming there's no material evidence when it comes to, the PCR tests. They're saying that there was arguments from the plaintiffs about the PCR test not being reliable, but that no material evidence was provided. What do you make of that?
Well, I have to say it's really early to be making those assessments. This is not an opportunity to test or weigh the evidence. Nobody's been cross-examined. None of that has happened. That's what happens in trial. That's the next step. Right now, the point of this whole hearing is whether or not and how to certify a class of BC residents so that they can bring a claim forward as one instead of all individually. It's not the time to assess any evidence at all, in my opinion.
One more thing you should know before we end this report is the advantages that will happen if certification is in fact granted. What would that mean? What would the society get out of this? And what does that mean to the people who want justice for what's happened with these mandates?
Well, what I would say is that finally Canadians have their day in court. This would, like I said, be an opportunity to test all that evidence that we've been talking about and not really knowing whether or not it's been correct, or whether or not the PCR tests were correct and valid and worth justifying all of these measures. Same with the vaccine mandates. So that's what Canadians would get out of it. We're not sure yet who the class would be. That's exactly, like I said, what this whole process is about. But even if it's a smaller class of BC residents, we're all going to be able to hear that evidence and finally test whether or not all of that evidence all of that information they were telling us was correct.
We'll finally know what science BC's provincial health officer is using to still to this day hold on to divisive vaccine mandates. I'm Drea Humphrey for Rebel News and
Eva Chipiuk.
If you appreciate that, unlike the state-backed media, Rebel News has been following cases like this in the Supreme Court the whole time, then consider supporting our independent journalism. We are completely viewer-funded, and we are nothing without you. You can do so by going to rebelnews.com and donating what you can.